Welcome to this explainer. I'm your host, and today we're diving into the absolute bedrock of the world's largest democracy, the Indian Constitution. Now, we're not just looking at dry text here. No way. We're going to examine the grand machinery of the state and really put it through the ultimate stress tests. We're going to watch the legislature, the executive, and the judiciary clash, find their balance, and literally hold this massive nation together. So sit up, pay close attention, and let's witness the raw power of constitutional law.
Here's our roadmap for today. First, legislature and executive powers. Second, the independent judiciary. Third, federalism and center-state relations. Fourth, trade, services, and elections. And finally, emergencies and amendments. All right, let's dive right in.
Unit 1, Legislature and Executive Powers.
So under Articles 79 to 122, we find the absolute foundation of our democracy. Parliament is split into two distinct houses. On one side, you've got the Lok Sabha, the House of the People. It's directly elected by the citizens, capped at 550 members, and runs for a 5-year term. This right here represents the direct, dynamic will of the masses. Contrast that with the Rajya Sabha, the Council of States. Indirectly elected, maximum 250 members, and crucially, it's a permanent body. 1/3 of its members retire every 2 years. So while the Lok Sabha brings dynamic, changing power, the Rajya Sabha brings that unshakable, long-term stability.
But make no mistake, when it comes to finances, the Lok Sabha asserts absolute dominance. Under Article 110, we have this concept called a money bill. If a bill strictly relates to taxation, borrowing, or the consolidated fund, the Speaker certifies it as a money bill. And once that happens, the Rajya Sabha is completely stripped of its veto power. They can only recommend changes. They absolutely cannot reject it. You have to understand this fundamental rule. If you control the money, you control the government.
Now what happens when the very members we elect just switch sides for pure political gain? Enter the anti-defection law, brought in by the 52nd Amendment as the 10th schedule, and the rules here are ruthless. You are instantly disqualified if you voluntarily give up your party membership or if you defy the party whip and vote against their directions without prior permission. Even a nominated member gets disqualified if they join a party after a 6-month grace period. The whole intention? Ensuring rock-solid political stability over pure opportunism. But this creates a massive constitutional clash, because the law made the Speaker the final authority on deciding these disqualifications. So we have to ask a really commanding question. Is the Speaker's absolute decision completely immune from judicial review? Think about the gravity of that for a second. Can a Speaker, who usually belongs to the ruling party, operate completely beyond the reach of the courts? Well, this exact question went right up to the apex court in the landmark 1993 case, Quijoto Halahan versus Zekiel Ho. And here is where the Supreme Court dropped the hammer. The court ruled that yes, the anti-defection law is constitutionally valid. However, and mark my words because this is absolutely crucial, no authority in India is beyond the reach of the courts. The Speaker's decision might be final, but it is 100% subject to judicial review on grounds of malafidas, which basically means bad faith or perversity. You just cannot violate natural justice and expect to hide behind a legislative shield.
Unit 2, the Independent Judiciary.
Okay, let's shift our focus to the fierce guardians of the Constitution. Under Article 124, it's the President who appoints Supreme Court judges. But here is the historic friction point. Does the executive or the judiciary actually have primacy in these appointments? Who truly holds the pen? For decades, the executive dominated this entire process. But the judiciary pushed back with immense force in the monumental Second Judges case of 1994.
The whole thing turned on, interpreting one single word: consultation. The Constitution states the President appoints judges after consultation with the Chief Justice of India. Well, in this 1994 verdict, the Supreme Court boldly declared that when it comes to judicial appointments, consultation actually means concurrence, meaning the executive cannot appoint a judge if the Chief Justice objects. This single ruling established the famous collegium system, decisively proving that judicial independence is a fundamental, untouchable part of the basic structure.
Decades later, Parliament actually tried to take that power back. Through the 99th Amendment, they created the National Judicial Appointments Commission, the NJAC, which gave the executive a massive say, including a veto in appointing judges. But listen to the sheer power of the 2016 Supreme Court verdict. They literally struck down a full constitutional amendment. They declared the NJAC unconstitutional. They said any executive veto over judicial appointments utterly destroys judicial independence and therefore destroys the basic structure itself.
The message was unmistakable. The judiciary remains fiercely, fiercely independent.
Unit 3, Federalism and Center-State Relations.
As you know, India is a union of states, and power is divided through three lists: union, state, and concurrent. But we need to understand this legal concept of repugnancy under Article 254. The concurrent list has subjects where both Parliament and the state can make laws. So what happens if they write completely opposite rules for the exact same subject? The Constitution is strict here. The central law prevails. The state law is void to the extent of the conflict, unless it specifically received presidential assent beforehand. At the end of the day, the center always retains the upper hand.
But how far does that upper hand actually go? Can the center weaponize the Constitution against its political opponents? You see, Article 356 allows the president to impose president's rule and essentially dismiss a state government. So ask yourself, can the president arbitrarily dismiss state governments simply on political grounds, like, say, a change in the ruling party at the center? To answer that, we look to the state of Rajasthan case in 1977 and the monumental S.R. Bommai case in 1994.
Historically, Article 356 was heavily misused, and dismissals were pretty common. But then the Supreme Court stepped in. In the state of Rajasthan case, they made the president's satisfaction justiciable, meaning, yes, the courts can and absolutely will review it. Then came S.R. Bommai in 1994, where the court laid down strict, undeniable guidelines. They ruled that a floor test in the assembly is the ultimate and only proof of a majority. Furthermore, they declared secularism as a part of the basic structure, meaning politically motivated dismissals just for having different party ideologies? Strictly unconstitutional.
Unit 4, Trade, Services, and Elections. Now we pivot from pure power dynamics to the functional flow of the nation. For a massive country to operate as one unified economic unit, trade has to flow freely. Article 301 explicitly declares that trade, commerce, and intercourse throughout India shall be free. But what happens when states get a bit greedy? Pose this critical issue to yourself. Can a state levy a transit tax on goods moving strictly through its borders? The Atiabari Tea Company faced this exact nightmare when Assam tried to tax tea simply for floating along inland waterways out of the state.
The 1961 Supreme Court ruling was definitive here. A tax on the mere movement of goods directly and immediately restricts the free trade guaranteed by Article 301. States simply cannot arbitrarily choke interstate commerce. If a state absolutely needs to restrict trade for the public interest, they have to use the strict constitutional safety valve of Article 304b, and that requires the restriction to be reasonable, and crucially, it requires prior presidential sanction. Basically, you cannot break the economic unity of India without the center's explicit permission.
Unit 5, Emergencies and Amendments.
All right, we now enter the most intense section of our explainer, the ultimate stress tests of the Constitution, where even fundamental rights can be suspended. Let's look at a national emergency under Article 352. After the historical controversies of the 1970s, the 44th Amendment introduced immense, necessary safeguards. Just trace this rigid timeline. First, the cabinet must provide formal, written advice, no more verbal orders. Second, the president issues the proclamation. Third, both houses must approve it within a very tight window of just 1 month using a special majority. And fourth, it's only valid for 6 months at a time. The whole machinery was deliberately made this strict to prevent any kind of tyranny.
But what about changing the Constitution itself? Article 368 gives us a 3-tiered constitutional machinery. Step 1 is a simple majority used for minor territorial or schedule changes. Step 2 is the powerful special majority. That's 2/3 of members present voting plus an absolute majority, and that's required for most core provisions. But Step 3? That is the hardest. If you want to alter the federal structure, the powers of the Supreme Court, or executive powers, you need that special majority plus ratification by at least half of the state legislatures across India.
But here is where the ultimate battle for supremacy took place. The Ninth Schedule was originally created to protect land reform laws from being bogged down in court. Over time, however, politicians started hiding all sorts of controversial laws in there. Which brings us to our final, monumental question. Are laws placed in the Ninth Schedule absolutely immune from judicial review? Can Parliament literally use this schedule as an impenetrable shield against the Supreme Court?
The answer came down like thunder in the 2007 IR Coelho case by a massive 9-judge Constitution bench. The Supreme Court ruled that no, the shield is not absolute.
Any law added to the Ninth Schedule after April 24, 1973, which is the exact date of the case of Unda Bharti judgment, is not immune. It must pass the basic structure test. If a law destroys the essence of fundamental rights, the Supreme Court will strike it down regardless of where Parliament tries to hide it. The basic structure doctrine is the absolute, unshakable law of the land.
We've seen the legislature draft the laws, the executive enforce them, and the judiciary fiercely protect the basic framework from destruction. So, I'll leave you with this final provocative thought. If the basic structure doctrine allows the unelected judiciary to strike down a constitutional amendment passed by the elected parliament, who truly holds supreme power in this democracy? Is it the parliament that writes the law or the court that protects the Constitution? Think deeply about that balance. Thank you for joining me on this explainer, and keep questioning the mechanics of power.